welcome back to another episode of I'll Allow It Nevada, your go-to podcast for quick insights into Nevada's judicial education. I'm your co-host, Seth Easley, representing the Supreme Court of Nevada Administrative Office of the Courts, Judicial Branch Training Unit. In our last episode, we began an informative discussion on judicial ethics. So let's jump back in with our host, Anne Marie Mayu, and our guest, Justice Linda Marie Bell of the Nevada Supreme Court and Judge Scott Freeman of the 2nd Judicial District Court to continue this very important discussion on this very important topic.
Let me shift gears and stay on the canons for just a moment, talk about an interesting canon. Our last canon talks about running for office, and it seems to stand the initial canons on their head, because it is acceptable not only by way of the canons, but decisional case law that has interpreted them, that we can solicit for campaign funds to the public, and those public members may appear before us, and there is no conflict of interest according to the canons and decisional case law. In addition, our opponent, who has lost the election and is back in private practice and didn't become a judge, can appear before us without a conflict of interest, despite all the mean things they may have said in the campaign. And that goes back to Justice Bell's adage that we have a duty to sit. And apparently, the canons and ethics case law agrees that we have a duty to sit. So a good question would be, how do we navigate someone who's given us a significant campaign contribution? And that kind of question comes up a lot, and they appear before you. And the reality of the situation may be different than the perception, but you have to be able to set that aside. If it is so overwhelming that the appearance of, in my view, that the appearance of impropriety is pervasive, it was the majority of your campaign funding was from this individual, there's no question you get off the case. The appearance of impropriety is too strong. But if it is not that circumstance, you have a duty to sit and a duty to sit on their case. You make the disclosures candidly are public as well with your finance disclosures that you make to run for office. And you hear their case and be as fair as you can, but you start with the gut. You cannot be fair because of the contribution and the relationship you have. You get off, or you disclose, and you disclose. And that's where the balance is. But what's interesting is that we've been talking about canons and how canons control the ethics and impartiality of judges. The same canons allow us to do things I just said because it's an elected piece. So there's very strong arguments for judges to be appointed in some ways, and that's not anything that's going to happen. The voters had the choice, and they've decided to elect our judges. So it's a necessary piece.
As limited as we are around the area of politics in general, Nevada actually allows judges to do more than many other places. We specifically did not adopt a couple of the subsections of the model rules of professional conduct. So we are allowed to purchase tickets for dinners or other events, or attend events for a candidate for public office. In other states, if Judge Freeman was running, I wouldn't be able to go to his event because he's a candidate for public office. But in Nevada, we are allowed to do that. Also, in other states, judges are not allowed to personally solicit or accept campaign contributions other than through a campaign committee. And there's specific rules about how that's supposed to work. Judges here, whether that's good or bad, I'm not sure, but judges here are permitted to do that. I think, though, we have to be extra mindful, given that we have a little more latitude in those areas, to make sure that we are being careful about, do we need to disclose this? Are we putting ourselves in a situation where it may impair our ability to make a decision in a case later, right? If I go to a political rally of some sort, and then the next week I have a ballot initiative case or some other election-related case, that could really be a problem, and it could compromise my ability to hear the case. As judges, we're supposed to put our judging job ahead of our personal interests, and we're not supposed to do things that create conflicts. Frankly, we have enough problems with conflicts without going out of our way to create more for ourselves. So it's just really important in this area, particularly as we're in election year, to be mindful of those limits on our political behavior.
That's so well said. I was smirking while you were speaking, Justice Bell,
Often.
because I had a example of when I was a criminal lawyer and I was running for judge initially. I received a campaign contribution from, he's now deceased, Dennis Hoff from the Moonlight Bunny Ranch House of Prostitution. Now, to be clear, I gave the check back. However, consistent with your analysis of how the canons work, I received a check from the Bunny Ranch for my campaign, and if I'd kept it, I'd have a lot of explaining to do. But the point being, that's perfectly allowed in Nevada. And so there's a really interesting balance when we talk about essentially everything being a conflict of interest in a pyramid analogy and then breaking it down, whether it affects your ability to be fair and impartial, has no effect, or remains neutral. You know, you have to think about who's giving you the campaign money too. It's
Right.
part of being a judge.
Where that's coming from.
That's right.
And I was just wondering, why would a judge choose, in a situation that might be a real conflict, why would they choose not to? Why would they choose that? Is it because they really truly don't feel it would be a conflict of interest? Or is it an appearance thing? They don't want to look like they can't?
I think there's a number of reasons that judges may not follow the rules. And I think the first is just lack of awareness. As I said in the beginning, these rules are not all intuitive. And many of the things that were perfectly okay to do as a lawyer are now not okay to do as a judge. And they can be very limiting. If someone was very involved in political activity and now can't really do any of those things, that can feel very limiting and very uncomfortable. People who have done all kinds of fundraising, you're doing a fun run and you post that on social media. That's a problem if you're a judge. That is completely normal behavior for somebody that's a lawyer, and you may not even think about it. So I think I would say most of the problems fall into that bucket of just not being aware. I think there are people that have different boundaries, what they're comfortable with or how much they're willing to push a particular issue. There's people who feel very strongly that they should be able to express a political opinion, and that can create some tension with the rules, and it may end up creating some guidance for us in terms of a disciplinary decision. I think most judges try really hard to get it right and to follow the rules, though.
Very well said. I couldn't improve upon those words. I think that the problem that judges have, to answer your question, is that I agree. It's they're not aware of it, and they don't understand how the interconnection of judicial ethics and canons and what's required of us as a matter of law apply to them. And that's where you get the really bad decisions. But it's true. Just because you're a politician once in every 6 years doesn't allow you to act like a traditional partisan politician. You're a member of a specific branch. I said now for the third time, we're a member of the judicial branch. There's a reason why we're separate. But that's actually a great question by you, because that's the problem. The problem is not understanding it and realizing it, and that you've given up certain ability. I had someone say to me, so I've given up my freedom of speech. Well, you have in some ways. And so, for example, the canons also provide that you could be subject to discipline for your everyday life sort of things. If you're mad at a referee in a soccer game, for example, and take it one step too far by being in their face and pointing your finger at them, that's subject to discipline. That's a judge is on duty 24/7, 365, and you're expected to act in a particular way. So, for example, depending on your choice, if a social group invites you to a social setting and there's cocktails being served, it's true. The old adage, I'm sober as a judge, comes to mind. Because, again, you're in the public. I didn't for a minute say you shouldn't drink, but it's a choice you should make in mixed company. You have a reputation. You're in a small town. Maybe that's something you might want to do in private. I'm not suggesting, if people say, "Oh, Judge Freeman, come on now. I like to have a cocktail with the lawyers after work." That's up to them. I don't do it, but that's up to them because I made a decision to be in this position. And so I don't expect to be on the front page of the paper for something I didn't want to be, because that has happened. And if you have that experience, you don't ever forget it. And it's significant to your reputation and your ability to continue in the occupation.
And it impacts the respect for the judiciary as a whole. When judges misstep in terms of ethical behavior, it is embarrassing to the entire judiciary. So we really have a very vested interest in making sure that everybody follows the rules.
Absolutely. And I think that, and I appreciate you entertaining that question. I would like to follow it up with, our Nevada judges are amazing, and our justices are phenomenal, and they are very dedicated and willing to do the job that many people don't do. So there are very far and few between issues because we do have pretty awesome judges.
While we pause for a quick break, I'd like to extend a special invitation to our listeners. I'll Allow in Nevada goes beyond just being a certified legal education podcast. It's crafted with inclusivity in mind, welcoming all who are interested. Our goal is to foster connections with communities and offer valuable insights into the Nevada judiciary. If you found our episodes engaging, we encourage you to spread the word and share this experience with your friends and family. Your support is greatly appreciated.
So are there any resources or support systems available to our Nevada judges for education and guidance on ethical matters?
Well, let's start with the AOC education.
Right.
There are classes given throughout the state on the issue of ethics. The District Judges Association meeting that was just last week always has an ethics component, as do many other CLE providers. The National Judicial College does ethics courses. New judges are required to take an ethics course from them. There are, as I already mentioned, the resources in terms of the Standing Committee on Judicial Ethics and the Judicial Discipline Commission, those advisory opinions and the disciplinary decisions. You can reach out to judicial discipline, and they may provide you guidance. Typically, they'll point you towards one of those advisory opinions or the particular rule. So sometimes you can just figure that out on your own. And I would also really encourage everyone to build a network of judges that they trust to help them navigate through difficult ethical decisions.
Very much so. I'm on the Standing Committee on Judicial Ethics as one of their members. And what Justice spoke about is we'll get unique questions that are fact-specific to a particular judge and get an opinion as to whether it's ethical pursuant to the canons and whether they can proceed. So it's very insightful, and it's very easy to do. The judge will send a written request to the Judicial Ethics Committee. It's on the website, and say, this is what I'm facing. Can I do it? Can I not do it? And typically, it's really amazing. There's actually opinions on most weird topics that could come up for a judge to the point that you ask for that opinion. And then that question, if it warrants, will allow for a new opinion based upon that particular question. So there's precedent being set by these unique fact patterns.
That process, as I mentioned before, it doesn't help you when your neighbor walks in as the witness in the middle of a bench trial, but it's very good for broader application, things that you are doing in general in your life. Can I sell Girl Scout cookies, or can I work at the stadium selling hot dogs for my kids' soccer team? Those kinds of questions.
I think our listeners would be interested in how you handled it when you walked in and saw a neighbor of yours in the middle of a trial. What process did you go through?
We took a timeout. I brought the lawyers up. I said, this gentleman is my neighbor. We participate in the same community organization on a frequent basis. And he has a very common name, and I did not know that till just now. And does anybody have a concern? Nobody had a concern, and nobody felt a need to take additional time to address it, or I would have given them that. And we really just kept rolling.
Based on your relationship with the neighbor, what did your gut tell you?
It wasn't a concern of mine that I had a bias or prejudice or couldn't be fair. Boy, that could have been really difficult if it was somebody that I had such a close personal friendship with that I couldn't be fair. I may have had to just stop the trial and find somebody else to do it. That would be really a difficult situation.
But the point is that was not the case. You did the
that was not the
you
case.
did the gut check first. You did the disclosure second, and they said carry on.
That's right.
You handled it absolutely correctly.
Thank you.
You're welcome.
Well, so I'm curious and I don't know if you can share this with us, Judge Freeman, but what's some of the weirdest requests or things that you've had? Can you?
Well, I'm going to go in the third person because
Yes.
When I was a lawyer, I had a boutique practice of representing judges in trouble with the Ethics Commission. So there's lots of experiences I had with judges where your show shouldn't be, I'll allow it. It should be, what were you thinking, right? And so there's lots of examples that are published opinions of lawyers that have gotten in trouble for making decisions or making choices that you really can't believe. But, typically, I'm going to say it in a reverse way, okay? In Washoe County, there's a judge who used to be a managing partner of a law firm, a local law firm in Reno, and she has made a blanket decision she won't hear any of those cases. Now, my question would be, after 10 years, can you still not hear one of those cases simply because you were a partner there? That's a decision for her to make, and whether or not she wants to make that disclosure, et cetera. That's kind of a reverse to your question of to me, after a certain amount of time, when the people that you associated with aren't there anymore, perhaps you could take another look at it as opposed to a blanket that the rest of us judges have to hear the cases involving that law firm because you happen to have worked there. More recently, I agree, but as it passes in time, that may be something to look at, just to look at, do the same analysis. But there have been, the published opinions have been so significant of what were you thinking. I simply share with you, I represented a justice of the peace in one of the rurals that wasn't a legally trained judge, and one of his friends got a speeding ticket. So he called up one of the highway patrolmen who issued the ticket, had him see him in chambers and said, I'd like you to take care of this. We all would think that, hey, wait a minute, what are you talking about? How can you possibly do that? He wasn't thinking, and I ended up representing him. Had another judge called up, son got in trouble. Instead of doing what he should have done, he called up the jail and said, I'm ORing my son, giving him a release on his own recognizance. Again, simple. Those are two outrageous examples you want. I'll give you a simpler example. A local judge got in a lot of trouble for being on the brochure and mailer for a charity event as one of its people that were going to be there, speak, and impliedly was a sponsor. Got in a lot of trouble for that, as Justice Bell has shared, related to charity events. Suppose, there's so many ways to analyze that, but suppose you're on the other side of the charity event. The judge, you appear in front of the judge. It just goes on and on about being fair and impartial and the appearance of being fair and impartial.
Well, and I think, too, when mistakes like that are made, it helps then the future judges go, oh, wait a minute, this is something that someone got in trouble with, so I need to rethink this.
Well, let me share with you the level of discipline, and Justice Bell will talk about it in greater detail, could be anywhere from a letter, let's say it differently, we got a case against you, says judicial discipline. Oh, my goodness, says the appropriately feeling judge. Let me examine what I did. To, I didn't do anything wrong. I'm going to make you prove it. You proved it. I'm being publicly admonished for next reelection campaign, up to the point of the death penalty, as I call it. You've been removed from office, and you may never run again. And you'll pay for all of the investigative costs involved in removing you from office. That's the far end of the spectrum. But that's kind of how judicial discipline works, and I'll defer to Justice Bell.
Consequences of making a bad decision can be really significant for a judge, especially in a state where we're all elected, right?
Okay, so we've kind of talked a little bit about this already, but how do ethical considerations impact public perception of the judiciary, and what steps can judges take to foster this trust in the judicial system?
Well, ethical considerations are everything in terms of perception of the judiciary, because our judicial ethics encompass not just don't take a bribe, but it also encompasses being competent at your job. So it's how you do the work every day. And I think the fundamentals are pretty basic. It's show up for work on time, be prepared, be respectful, equally respectful to everybody who appears in your court, and be very mindful of the ethical concerns that can arise. Do I have a conflict? Is there a bias or prejudice here? Can I participate in this activity without impacting my job as a judge? The fundamentals are not difficult, really important, though, to follow, I think.
No, I totally agree with Justice Bell, and also say that, as I said earlier, fairness is the key. Being fair. I mean, to me, it doesn't matter to me what your race, your religious background is, your private beliefs. If I'm a lawyer, I want to be assured that when I'm before Judge Freeman, that he's just going to be fair. We have such wide discretion. There are so few guidance rules when we sentence a defendant in the criminal arena. There's so few rules when we have a bench trial and we have to make a decision of what law we're going to follow to find the right verdict. And of course, as the ringmaster herding juries, we want to make sure they make the right decision. The public is entitled to depend on the fact that we're going to do it fairly. That's what they want. That's not a catchphrase. So-and-so is entitled to a fair trial. They're entitled to a fair judge. And that's what the canons and rules of ethics provide. And if you're struggling with it as a judge, you shouldn't be one. That's what I think.
Fair enough. So are there, in this ever-changing world, are there any emerging ethical challenges or trends that Nevada judges should be aware of? And how can our judges adapt to evolving ethical standards?
So one of the current considerations in the ABA model code world is technological competence. So as I mentioned before, the ethics rules encompass more than decision making about conflicts. It also requires judges to be competent. And so there is consideration of rules to require judges to understand technology and to be able to use technologies. I think that's something that's on the forefront, and it's important. Electronic discovery, electronic case management systems, those things are all in play or coming. And it's important for judges to have a good understanding of how those things work to continue to do their job well.
Such a good point by Justice Bell. It's another example of, I didn't see that coming. How do I process it based on what I know? So you do the same, in my view, you do the same analysis, and then it may end up in the courts in terms of whether you made the right call, whether you applied the ethics and canons correctly, and giving us additional guidance as those emerging trends occur. Social media, of course, the artificial intelligence, of course, that's all coming. And so the only guidance I think of that would guide myself in my practice as a judge is, I didn't see that coming. I'm going to do the analysis that I'm used to and see how it comes out. What's my gut say? Should I disclose? Do I need to get off the case? Let everybody know, see where it goes.
And AI is becoming such a big topic in any business or organization that you talk to. So is it coming? No, it's here, right? It's here. So reacting timely too, I think, would be important as well.
So this has been an awesome conversation. Thank you guys very much. To kind of just round out this discussion, what do you believe is the most crucial aspect for judges to remember when it comes to upholding judicial ethics? And is there anything else you guys just want to mention?
I think unlike most jobs, we are judges 24/7, and the rules apply to everything that we do 24/7. We have limits and rules that other people do not have, other lawyers do not have, and our conduct off the job is often as important as our conduct on the job.
And it goes back to my watchword of being fair. We make decisions that affect everyone's life. Justice Bell makes decisions that affect everyone's life in our state. And so I expect as a member of the public, Justice Bell's going to be fair when she makes those decisions without being hindered by anything other than being ethical and being fair. And so if I'm confident in that, I know she'll make a decision, whether I agree with it or not, but it's related to the law and what's right, and not because her sister works for a casino. And that's really important.
And you don't have to guess at what those ethical standards are, because there's plenty of resources out there that you can look at that'll guide you. So,
all right. Well, thank you guys again very much for being here. This conversation was awesome. I think a lot of great, valuable information for all our listeners, judges, as well as the general public. So thanks again.
Thank you.
And we're going to close out.
I'll allow it.
will you?
Heartfelt appreciation to our guests and to everyone who has tuned into this podcast. Before we wrap up, here are a couple of important reminders. For continuing legal education credit, be sure to complete a certificate of attendance and email it to jepodcast@nvcourts.nv.gov. And if you have any questions, topic suggestions, or comments, we welcome your input. Please email them to jepodcast@nvcourts.nv.gov. We value and look forward to hearing from our listeners. Stay tuned for more episodes of I'll Allow It Nevada, released every first and third Friday of the month. This is Seth Easley signing off. Take care, Nevada.